Your hosts have earned a reputation as fierce and effective advocates inside and outside of the courtroom. Our partners are experienced trial attorneys who've been board certified in family law by the Texas Board of Legal Specialization.
Thank you for tuning in to the For Better, Worse, or Divorce podcast, where we provide you tips and insight on how to navigate divorce and child custody situations in the state of Texas. I'm Brian Walters, and today I'm joined by one of our firm's associate attorneys in Houston, Jaylin Jackson. And today we're going to discuss something we discuss about every 2 years. When the legislature comes out with new laws, they impose them on us. It changes family law, and they go into effect September 1st in almost all cases. So that's what we're going to talk about. There's a whole new set of them here for this year, 2025, and we're going to go into them. But first, Jaylin, tell us a little bit about yourself, not just the boring stuff about where you went to law school or what law review or whatever you were on. Tell us like something interesting. Where'd you grow up? All hobbies, something that makes us attorneys a little bit human, which is difficult, I know.
Fair. Thanks, Brian. My name's Jaylin Jackson. Something interesting about me is I am a dog mom of a Pomeranian. I love him a lot. He turns 10 this year, actually. I'm the oldest of my siblings. I have 6 siblings, and I did go to law school at Thurgood Marshall School of Law. I graduated in 2020, and I have been practicing family law ever since.
Wow, I didn't know you had 6 siblings. That's great. Makes for never a boring childhood. Were you in the middle? Are you the oldest or youngest or where?
I'm the oldest. Like, my parents divorced, and then I have a stepsister who's older than me, but I still technically feel like I'm the oldest.
Yeah. Got it. I met with a gentleman today who's got 8 children, and so I thought that was kind of a record, but evidently you guys are close.
Yeah,
close
we're neck
behind
and
that.
neck.
All right. So, okay. Well, so there's always a lot of changes, and so what we've done is kind of narrow this down to the ones that are the most important or make the most effect on us. And the first one is child support, and it's technically not a change in the law. What it is that our child support guidelines, kind of our max number, mostly max number, gets reset every 5 or 6 years to reflect the trailing inflation. And that just happened also on September 1st, which is a coincidence, but that's probably affected the most cases right away because that affects a lot of cases. But tell us a little bit about that and how that works and what somebody can expect. And maybe the other part to discuss is, what does that mean for my child support? Either paying it or receiving it. So why don't you give us some insight on that stuff?
Sure. So the changes that we're seeing as of September 1st, 2025 are that the cap for child support has raised from $9,200 to $11,700. So that means when the court is looking at a person's income that would be considered for child support, their monthly income, they are now looking at the first $11,700 instead of $9,200. And so if you have one child, you would pay 20% of the first $11,700 that you make as max. If you make more than $11,700 or right at that number. For 2 children, you'll pay 25% of that number, and for 3 children, 30%. So that makes the max guidelines child support for one child increase from $1,840 to $2,340. For 2 children, the max amount is $2,925. For 3 children, the max amount is $3,510. I could go on, but essentially that means that Texas just makes it to where you can't have infinite child support. They kind of cap it at how much income they will consider. With regard to what that means for someone's case now, this law takes effect obviously September 1st. But the change applies to new cases, pending cases, and modifications that are finalized on or after September 1st. So obviously, if you file a case now, you're going to have your case considered according to the new child support rules. And if your case was filed before September 1st, but it finalizes after September 1st, then you still get to take advantage of that. So.
Yeah, I agree. And so what this means for people listening is a practical matter if you're under a child support order or either paying or receiving, is that if the person paying is above the cap, I used to think it was somebody making about $150,000 a year roughly would be the cap. And if you made above that, you paid the same amount. It's now, I think, essentially like $190,000 a year. So if you're paying or receiving from somebody like that who's above the cap, it's an automatic change in child support. You just have to file for it, and if you ask the attorney general to review it, they should do that for you at no cost. That can be slow, but it will happen. Sometimes people hire private attorneys to do it. And the other thing I guess I'd say about this is it's sort of like, as far as the amount paid on the cap, is sort of like you had another kid, and but you don't really have a kid. So if you had two kids, what you used to pay two on is now like paying three in the old days. But you still only have two kids. So that's the way it works. Obviously, there's been a lot of inflation over the past several years, especially 2021, 2022 area. So that's affected things a lot. And so anyway, there's that. I think maybe the next most common thing that people would deal with would be enforcements, especially in possession and access. So this is if somebody's denying you access to your child, like, hey, it's my weekend. No, it's dad. I don't care. Or vice versa, someone's saying, "Hey, it's my weekend," to you, and you're the custodial parent, and you think it is your weekend, and you say, "No, look at the order," and they sue you and say, "Well, actually, you're wrong." So, basically, what this looks like is, to me, that the court has gotten kind of mad at repeat offenders, and has kind of upped the penalties for someone who's I think in your notes, Jaylin, you said three strikes and you're out. That's a good example of it. Basically, if you found to have violated court orders for possession access three times, some bad things can happen to you that didn't happen before. So maybe you want to go through what those changes are and how that works and all that.
Yes, for sure. So with regard to enforcement, so in order to have an enforcement, you have to have a court order. So this only applies to individuals with a court order that says you're supposed to have possession on X, Y, and Z day. And so if you are being denied possession and access pursuant to your court order, then you can file a motion for enforcement. And if you do file the motion for enforcement, the court now they're required to give you makeup time. Previously, they were allowed to give you makeup time. There was a may, the legislature changed may to shall. So now the court has to, only if the opposing party is unable to prove that there's good cause why the court should not render the order. So basically, the other side still does have the ability to argue, hey, judge, don't give them any extra time. But if that argument doesn't convince the judge, then the judge is required to give that person that's been denied their access additional makeup time. And then with regard to the makeup time, like the amount of makeup time you can get, it's supposed to be equal to the amount of time that you were denied. However, if you are dealing with a repeat offender, meaning someone who's continuously denying you possession and access that you were court ordered, the court shall order makeup time in the amount of two times the amount of the possession that you were denied. So if you were denied 2 days, you would get 4 days essentially. And that is just the bare minimum. I think this is, like Brian said, a really good indicator that the court is not happy with repeat offenders. And so I think it's worth noting that this is the baseline of what the court should order, but it doesn't have any restriction on the court ordering more time than just two times the amount. So that's something to keep in mind.
Yeah, and I think this makes sense. I mean, this has always been part of the problem with enforcements, or contempts. It's called the same thing. They're very difficult under Texas law. There's a old case law about it, but basically, it's always been very difficult to find someone in violation of a court order. They have to be written like really precisely, and it has to be real clear that they violated, not just maybe and sort of. And so, people would come to us and say, "Look, mom, whenever she feels like it, every couple of times a year, she'll deny me a possession period just because she's being difficult or wants to go on a trip or whatever." And we would often say, "Well, we're not sure we can prove it because it'll be he said, she said, and it's going to cost you money." And we get there, and the best that can happen to you is you get made up whole, right? Like you get your time back. You miss 3 days, you get 3 days back, and you get your attorney fees back. But you can't get, that's not, maybe not that much of a punishment for the other side. They're like, well, I kept 3 days from him anyway, and now I just had to give him back. Who cares? Some people don't care that much about money. So this actually gives the court some ways to really up the penalty and make it really painful, hopefully, for the person who's the repeat violator. So next, probably in order of importance that we deal with, is grandparent access and possession in custody cases. Now, these are extremely complicated cases. There's federal law, constitutional law, family law, all this other kind of stuff that's kind of interplayed into the family code section. And we try very hard in this state to give parents the right to raise their kids, and except in very rare circumstances. But those circumstances do exist. So, and there's very complex things about standing and burdens of proof and all this other type of stuff that, frankly, I don't think most lawyers understand, and certainly not many I've dealt with. And so now they've changed it to make it so it's different and even more, in my view, more complicated. But that's the legislature's choice. So I don't think we want to go into great detail about every part of this, because we would be in a really long podcast. But if you want to give us sort of the highlights, Jaylin, and because I know there are a lot of grandparents listening out there and are, want to make sure their grandkids are taken care of.
Sure. So, with regard to grandparents or relatives, they may intervene in a pending suit to request visitation, meaning the parents or the managing conservator or guardian of the child has already filed a suit affecting the parent child relationship. So, a grandparent or a relative can file a lawsuit basically saying, "Hey, judge, I would like to get in on this. I would like to have some visitation with the child." However, they have to show that there is satisfactory proof that the appointment of the parents as joint managing conservators or of one parent as a sole managing conservator would present a significant impairment to the physical and emotional development of the child. That's a Satisfactory proof is a low burden, but it is technically hard to prove significant impairment of physical or emotional development without documentary evidence or possibly the evidence or testimony, excuse me, of a therapist or something like that. That can really show that the child is would experience negative impacts if their parents were essentially the ones that were only allowed to have access to them. So that's one portion of it. Non-related individuals can also intervene, but the parents would have to consent to these people intervening. So this would be someone who's not a cousin, not a sister, not a brother, not related to the child at all. They can intervene, but parents have to consent. And then I think the biggest portion of it is just the fact that the grandparents would now also need to include an affidavit attached to their petition, an affidavit for grandparents or for non relatives. They would need to include the affidavit that shows that if the court were to deny the relief that they're requesting, then the child would be significantly impaired. And so this would require you to have facts inside of your affidavit that are personally known by you, that you've observed, or that someone has told you. And it's very important that it's filed at the same time as your petition to intervene. Otherwise, you run the risk of your petition to intervene being kicked out completely. So I think that's a really big change.
Yeah, that's a great summary. I mean, it's always been difficult to intervene for custody or visitation as a grandparent, or even harder as anybody that's not a parent. Um, and they've just made it that much more difficult. Now, in some ways, I'll say that they've made it a little clearer too. There were some areas that were a little bit unclear about what had to be shown and what the standard was, et cetera. But they've now made it very clear, and they've made essentially every step of the way it's going to be hard. And again, that's because the underlying public policy is we want parents to raise their kids and not have, without really rare circumstances, have grandparents, aunts, uncles, neighbors, whatever, dropping in to take over their kids. And you can understand that. And so they're trying to weigh the two things, the need for safety and the best interest of a child, but also a parent's inherent rights. And so that's what we have. All right, let's cover one more topic, which is there's some changes to protective orders, which of course are designed to protect people, children, adults, even pets at this point, from family violence and the various forms that that can take. And so there have been some unclear things in the family code, I'll say also. Plus, there's been, I would say, some judges who've been dealing with protective orders in the past who have taken some liberty about things, links of them, or some things related to that. And so the legislature cleaned up several parts of it and to make it, I think, cleaner, clearer, and less subject to maybe a kind of a runaway judge too. So if you want to give us them, they're really, I think, two main areas. But if you want to give us a quick summary of those as well, and then we'll wrap up.
Sure. So, first, a summary of the duration of a protective order. So, essentially, there was an issue with regard to when the clock for the expiration of a temporary order started. Like Brian said, the legislature has cleared that up. And if a protective order is granted, and the person who is the respondent to the protective order, meaning the order is protecting the applicant from that person, if they are a party to a pending divorce, or if they are a party to a SAPSR, or if they are the defendant in a criminal case, essentially the protective order clock for expiration doesn't start until the day the judge signs the final decree of divorce or the order in the suit affecting the parent-child relationship or the criminal case. So that is helpful because sometimes protective orders are filed simultaneously at the time of a divorce or the time of a SAPSR, and it could take a while for the divorce or the suit affecting parent-child relationship to conclude. And so this just ensures that the protected person will be protected for at least 2 years from the date that they get a final order. So I think that's beneficial for the protected person. Um, and then the other portion that I think we should highlight is the transfer of the protective order. And I think this is to stop individuals from using the protective order as a tool to gain leverage in a divorce lawsuit or in a suit affecting parent-child relationship. And so now, if a divorce or a SAPSR is short for suit affecting parent-child relationship, is filed after a protective order is filed, then on the motion of a party or if the court just decides to on their own, they will transfer their protective order case to the divorce court or to the court that is handling the suit of affecting parent-child relationship, only if the judge determines that transferring this lawsuit won't negatively impact a protected person. And I can't really think of a way that, off the top of my head, I can't really think of a scenario where a transfer would cause harm. That doesn't mean that there wouldn't. And then another thing to consider is that if a protective order is rendered after a final order or a SAPSR is completed, then the court shall transfer the protective order case to the court that was determining the suit affecting parent-child relationship. Again, if the court determines that the transfer won't negatively impact the protected person. So it's just to prevent, in my mind, I think it's to prevent forum shopping. It's to prevent like conflicting orders from being rendered, and just to have some continuity between um, court orders for people.
Yeah, I agree. I think that cleans up some of these issues. And that could be an issue, right? I mean, if you had a protective order in one county and a divorce in another, there are 254 counties in Texas. And so you might think, oh, here's the divorce. That's all there is to this case. And yet there's a protective order, 5 counties over and nobody knows. So now hopefully be able to find it. There's no way that I'm aware of to do, at least not easily, a kind of a statewide search to all 254 counties. In fact, they've each one individually made it harder and harder every year to to find anything. But anyway, okay. Well, that's all we have for today. If you like what you've heard, do us a favor and leave a review. We appreciate all your feedback, especially when it helps us better the podcast. If you have any follow-up questions to this episode or would like to talk to one of us directly about your family law situation, just reach out to us at podcast@waltersgilbreth.com, or you can contact us directly through our website, waltersgilbreth.com. I'm Brian Walters with Jaylin Jackson, and thank you for listening.
For information about the topics covered in today's episode and more, you can visit our website at waltersgilbreth.com. Thanks for tuning in to today's episode of For Better, Worse, or Divorce, where we post new episodes every first and third Wednesday. Do you have a topic you want discussed or a question for our hosts? Email us at podcast@waltersgilbreth.com. Thanks for listening. Until next time.